To begin with. I mean, labor laws. Before learning or to understand what is law in general. So, going back to the questions of how probably labor laws, social or the society in general, and this is something that probably we have listened to the Hamlin lectures on labor and law and has provided us how possibly that technique works as a regulation of social power. And this is true in case of labor laws as well as it is for the other aspects of any legal system. So the power is identified as the capacity which effective or it is effectively to direct the behavior of others, and it is unevenly distributed in the society. So we really understand that there is some kind of a power equations that are available. Even in the labor law context, we have the the employer employee, and we also realize that okay, the level playing field of both the system, both employer and employee may not be on the right path. And it is also in this context we try to understand why labor regulations are important. And labor law is chiefly concerned with this elementary phenomena of social power or these equations. And in the earlier times, like for example, when you look at the principal purpose of labor law was to regulate, to support, and to restrain the power of management and the power of labor force. And so the idea essentially was that okay, there is the power inequality, so there requires certain regulation that needs to be put in. It could also be there should be restraint in the power that is provided. It is also significant that power of labor force also needs to be reinforced. So this is the context. And of course, yes, there are certain abstractions here and there. Like for example, in the original sense, or at least in the earlier times, the sense or the meaning of words management and labor did not denote the persons but the activities such as planning, or it could be the regulating the production and so on and so forth. It could be the distribution, coordinating the capital, etc., etc. But in the current context, in the current scenario, we understand there is a slight change in the words that we used as far as management and labor is concerned. And it may not be that we used to denote right now not only the activities but also people. And please remember, one of the most significant feature of our contemporary economic and social development is the rapidly growing overlap of management and labor. I'll quickly explain this with that of a example. Like the popular stores here, probably we find that a production manager or the head of the store is identified as a manager from the bottoms level, and labor from the above level, or it is also the same person plays the role of a manager from the part of management, and he also forms part of labor. So there could be critical the distinction, the earlier clear distinction of these two may have reduced. So this is in the context, or this is just to set the discussion in motion, to realize that there are changing contours in terms of how labor itself is understood, let alone laws that are required to regulate, but it is in this context. And in that level, another important feature is that the changing nature of work that we are involved in. So how we would say that this is how there is a change. So the another critical feature is the rise of freelancers or rise of gig economy workers. So this is not a new term as far as we are concerned, because we realize that of course there is the question, or there is a demand for certain work to be done in a specific manner, or even the businesses are not possible to intake a lot of people, and we realize that the changing nature, even that is also similar to any of the labor strategies that we look at, or even for that matter in the terms of understanding of employment itself. So let us see how probably what is gig economy? How does is the gig worker represented correctly, or is do gig workers get a fair deal in that context? Also, let us look at how equipped are our labor laws. Does the need for making labor laws a business friendly one sometimes sacrifice the question and interest of the workers? So these are the critical aspects that we look at. So it is not that the business friendly laws, or in those lines, if it sacrifices the work or the benefits that are required for a workforce, then probably there is a difficult line that we draw. In the similar matter, it is also reverse in that case as well. So to just to give you a sense of why this discussion is required, or why gig economy discussion needs to be part of labor law, is because unlike the earlier times, we realize that gig economy is rising, and there have been critical studies all over the globe that is being done to understand why and how probably the gig economy, or what is the rising percentage of people involved. It could be because of various factors, because it could be the flexibility that it offers, because you can work at the time that is available with you, with the limitations or with the positive aspects that you have. So you yourself being the whole spirit of the workforce. It could also be because of, for example, if you look at how probably we have seen that almost 25 or 24 percentage of online labor market, that is also seen as it is rising in that context. And I'm sure that pandemic has also given us much more opportunity in that level. So if the study is conducted here in the recent times, you would have realized that there is yet another rise in percentage of people involved in freelancing or such other gig work that is involved. And the media reports or media studies also show us that almost 40 percentage of the workforce, it also have somewhere around 15 skilled professionals that are involved in contract based work and in the freelance industry. So it is also on the same matter, according to Intuit, one of those the study also shows that how gig economy workers will almost represent 43% somewhere by 2020. So in this context, I'm sure that these numbers are going to rise. So which almost shows us that our traditional thinking of a public sector, maybe a public sector undertaken, or working workmen under that PSUs probably, or a private employee, unlike this traditional definition, maybe we have to think a little further and see how probably what is the change that is required. So this is just to set the base as far as gig economy is concerned. So the figures that it shows, it also involves, like for example, if you look at the percentage of job, and this is something that I should have mentioned it much earlier. So this is just a discussion. The references are provided towards the end, and of course it is not possible for us to completely provide for all the references, but major how probably, this is just to show you how what is the percentage in which that the jobs that are sourced in a gig economy. Like for example, recruitment firms. You also have social media platforms that are linked into. It could also be on online market. So the gig economy worker finds work from different platforms. So that is also interesting to see that it is a change from the traditional setup. So this is to set the base. So the basic fundamental idea is that gig economy is rising, and it is rising to that extent that the labor laws need to be revamped in such a manner that we include the non-traditional workers as well. So moving on to, I was mentioning about gig economy and its importance, significance, so on and so forth. But technically, who is the gig worker that we are mentioning about? Whom are we discussing about? So technically, when you look at, if you would want to understand the definition, probably that's how we do, right? So if the term is not clear to us, we go back and find what exactly is the definition. How is a gig worker defined? So technically, a gig worker is a non-traditional, or gig work consists of income earning activities outside a traditional long-term employee-employer relation. And this could also include freelancing. It could also be workers who are employed for certain projects or contract basis. It could be project based that they are being employed, or it could be simply short-term work that has been done. Does this definition stop here? The definition here, the definition, this is just one definition, probably I would say, or it just trying to encapsulate all the possible aspects of how a gig worker could be understood. But this is not the only definition. Moving on further, so I said, include freelancer also. So the pandemic had also brought us that, for example, the movie technicians. Under the earlier context, we may not realize that the workforce of a gig economy would contain media technicians as well, or movie technicians. And the pandemic showed us how probably they had movie technicians, or stage artists for that matter, performing artists, and so on and so forth. How their basic livelihood was affected. So that also shows that how there is how the gig workers actually consist of the percentage. And this includes workers on a contractual basis as well. It could be project based or short-term based. And another set of another set, probably we can call it as is the platform-based worker, who also include food delivery partners, who work with food delivery partners, and our Swiggy or Zomato for that matter, the work, the delivery. So that is also identified as a gig workforce. So does this is this the holistic definition that we can talk about? No, definitely not. Let us look at what are the other approaches that are looked into. Another approach, or the approaches to identify a gig worker. So some definitions are based on the work arrangement. So there could be situations where the fundamental idea might be that it is traditionally out of the employer-employee relationship, but it could be based on the work arrangement. It could be the nature of work that is involved. It could be basis of the legal classification that it creates. Like, for example, if you look at the definition in terms of a work arrangement, that is employer, employee, wages, salary. But now they have it could be also in this context, you have the person is attached to an employer, but he or she may not be the same person who pays the employee. Like for example, if you look at probably Ola or Uber can be one model in which just to give you an example. So the person, the driver might be might be a person employed, or is not employed, attached, probably you can say, because we have another consequence of identifying Ola and Uber, whether they are employees or independent contractors and so on. So but the question here is, the person is attached to a particular company, but the person who pays the person might be the customer. So the work arrangement could be one method trying to identify the gig worker. And it could also, so that is one set or one way of identifying. The other is, and such work arrangements are often called as non-standard work arrangements. But please remember, when we say that it is a non-standard form of arrangement, there are many more to come. So we might find it a confusing way to realize that, the way in which that work, the simple definition of an employee has changed to a great, it has undergone a clean change in that context. And the other could be the alternative, or maybe it could be freelance work that they do. It could be temporary agency work, could be self-employment, could be subcontracting as well. So the other definition could be the nature of work. It could be the day-to-day basis that they are looking at, because you would want flexible work hours that are required, may not have a direct oversight. It could be that you are employed for a particular project and you are working in that context. You just have to complete the report and send it. Probably you may not have to there is no direct supervision or supervising in that context. So this could be another nature of work. The other could be the issue of how legally are you classified. So why I stress upon the point of why different definitions are given is that all of these have an impact in understanding the labor laws, or the laws that are generally provided. So technically, in a common sense understanding of a labor law is that it is not only that it would regulate, but it would also help the labor force the benefits that they are due. Right. It is not only that the business is regulated in that manner, but also the benefits are provided. So when you talk about non-traditional or gig work under the legal classification, the general question that they ask is about how they are employees, whether they are employees or independent contractors. So here comes the issue of how probably how on the question we can understand this question in terms of a question that is often raised. I think this was in discussion for in 2016 and 17, we realized that this question had come up, whether employee is the person is an employee or an independent contractor, especially when it comes to Uber drivers. Hemant, is there any internet connectivity issue? Am I clearly audible and visible?
Yes, Suchithra, you are clearly audible and visual. There's no issue as such.
No issue, right?
Yes.
Thank you. Yeah, nowadays rather than we wishing good morning and good evening in in this kind of a setting, mostly the often asked question is, can you hear me, can you see me, right? So that has become the key word these days. Okay, so to coming back to what we were looking at, Uber drivers, whether they fall under employees or independent contract workers, why there is a problem is that when we look at how the simple question of whether Uber driver is an employee or a independent contractor, this is just a simple proposition. We just need to identify that. That is it. In this simple question itself, we find different jurisdictions having different opinion about it, and we also have certain jurisdictions which are not clear in terms of the nature, or not clear. They do not have a clear answer. So let's dive deep into it and see how that works. So to begin with, as I've already mentioned, since there is no clear concrete answer, let's just have a quick look. So as far as Uber is concerned, the Uber says that it is all drivers on its platform and partners are identified as independent contractors. And please remember, they very tactfully put it, or like, in a very marketing way, you can say, they call us as partners, or the Uber drivers as partners, and would also say that they are independent contractors. We definitely doubt that intention, because when you say the person is an employee, benefits come into picture. A lot many contractual obligation comes into picture, which probably the company may not want to entertain. So in UK, so 2016 and 17, we have seen that how employment tribunal ruled that the driver cannot be considered cannot be considered as a self-employed one, should be technically understood as a regular worker. And in that context, we also realize, I mean, the regular worker, and in terms of this is in the context of the case law, that is UK Employment Tribunal versus Aslam, and that is in the year 2016. This also went up to the appeals, and the court also clearly stated that no, we cannot identify them as independent workers, because of the reason that it is about to mention, that it should be considered as regular workers. Also, on the same note, in the similar manner, in Switzerland, the SUA is basically, we can call it as an insurance, or it also looks at how social welfare has to be provided for its social security measures or mechanisms that they look at. Qualified Uber on behalf of the Social Security Agency and said that they are employees. They can be only classified as employees. The Swiss State Secretariat for Economic Affairs also affirmed it. And the simple justification that they gave is that Uber driver cannot build his own client base or fix the prices, which he or she thinks it is fair enough. These characteristics make the driver an employee of the company. So at least we are clear that, okay, when it comes to employee, because of these limitations, we say this is the employee. Fine. So this is one aspect to it. Do we stop here? No, sadly, no. In the United States, that the thinking goes, it is in a different platform. The District Court of Pennsylvania declared Uber drivers as independent contractors, and the state of Florida also affirmed it. And also, please remember, we can also see that, how probably we would also realize how there is that, the kind of the ABC test that they provide, the state of California provides for, saying that, okay, these are the checklists that are required, and we find that this is an independent contractor. That is clear. And so we saw that, so somewhere the person is an employee. Here you have saying that the independent contractor, and the US courts are very clear in saying that no, they are independent contractors. One simple reason is the company themselves offers it in that manner, and also the ABC test that the state had approved of. Okay, so fine. Another comes the question, right? I'm sure that the next question that you would ask is, okay, fine, you said about other jurisdiction, tell us what is happening in India. This is a curious case, I would say, because we realize that even when we had the sweeping changes in the labor regulations, we brought in lot many changes. We had the different ideas of how probably industrial relations had to be, the industrial relations code, the social security code, so on and so forth. We brought out beautiful amendments, or we tried to come up with a comprehensive legislation. But sadly, when we look at the status, this simple status, we are unable, or we are not clear still as to how, whether they are partners or employees. And I'll quickly take you to this incident of how probably we can, I'm sure that you would remember somewhere in 2017 or 18, in the state of Karnataka, there was a strike by the Uber drivers, for the simple reason that they had an issue with the rules that they had come up with. And but the question there was, the case name is Satish N versus State of Karnataka, which discusses or talks about how an aggregator, who is an aggregator, can the aggregator rules 2016 is valid, because yeah, under the rules specifically the Uber drivers are just out of the game. So you fall or you stand nowhere as to whether you are a driver, you are an employee. Does your aggregator have certain obligations to be fulfilled to you, so on and so forth, etc. So the idea, or why I would say that it is still unclear, is because the labor laws also do not have a critical answer. So this is the point where we are trying to figure out whether we can give some kind of an answer. If not, at least what suggestions can we provide in order to see. So this just to give you an idea or overall picture of how there is a lack of clarity in terming of understanding who the worker is. And in terms of how probably the Indian laws, so now we look at how Indian laws are, like, are situated as far as gig economy workers are concerned. So when I said about how there is it is not clear, I'm sure that most of you would have gone back and searched, no, I remember there is some law that had come up. I remember reading it. Probably I'm sure that you would have checked. So you are right to a certain extent, and you are wrong to a certain extent, sadly. So to start with, the Contract Labor Regulation and Abolition Act somewhere tries to regulate the contract labor. And the interesting part is there is the idea of third party contractors covered. So this is how generally we say, okay, gig workers can also be made part of this because the third party contracts are covered. That is, of course, an interesting aspect, and it is correct to a certain extent. And as I have indicated already, Indian law, we have this notion of probably we have okay, this is how there is the public sector or public employees, government employees come into picture. You have employees who are governed under the PSCs that they are coming, and you have the private sector. Of course, the other sector of how probably organized labor and so on and so forth, that's a different context. But this is how generally we realize. But all the why I would stress the importance of being identified as a worker in any of these sectors is for the simple reason that certain working conditions, certain privileges are provided with you. And for example, the Minimum Wages Act 1948, a gig economy worker lacks this employee status, whether it is it is not that. Probably I'm sure that the first question that you would have is, of course, the person chose to be a freelancer. The person doesn't want to be attached to any particular probably an institution or a corporate or blah blah blah, whatever the nature of the corporate entity or the responsibility authority is. The person chose, right? Probably that would be the answer. But can we leave them by saying that, oh, this was only your choice in that context? So the gig worker lacks this kind of a status under the Indian law, and it also thereby results in several consequences. And the consequences probably is one is the most the saddest issue is that it will not be able to form unions or such other to represent one's interest. And also in those lines, how probably the exploitation part of it. So there have been certain incidents. I'm sure that this is something that we all would have faced when we talk to the Uber driver or Ola drivers. Probably they would have said, "Oh, yeah, they don't pay us the money." So of course, yes, even though the problem lies also in terms of the person may not receive the amount that is due for the person. And most of the time, the work arrangement could also have certain issues as well. So let's come back to what the law says. So the contract labor regulates the engagement of contract labor in India, including the work done by third party party contractors. And there is a scope for gig economy workers who also happen to be platform or to be the contractors, third party contractors under these law. So this imposes an obligation on the employer to comply with the requirements such as welfare and health obligations. But yet this law is still not applicable in that it is not widely discussed in courts. So the question is how probably the employment compensation, yet another interesting legislation is about how Employment Compensation Act of 1923, it mandates the employer to pay in case of accidents arising in and around the course of employment. But if the applicability of this law to gig worker also remained undetermined by the courts. And if in this context, this also applied to gig workers, and it would also, if at all these laws are applied, probably we will also have ensuring that the compensation for occupational safety hazard. And also the next question is about how probably what are the new legislation, how do we look at. So the new labor codes of 2019 defines a gig worker as a person who performs work or participates in a work arrangement, earns from such activities outside the traditional employer-employee relationship. So probably we are quite happy to see that, okay, there is a definition that is being provided, and the definition as of now seems to be very comprehensive. But I would say that it is not as comprehensive as we think in the first reading. So they are entitled, they are entitled to life and disability cover, health and maternity benefits, old age protection, and other protections as determined by the central government, which will frame social security schemes for them. So there comes the problem. So when we read closely the labor codes of 2019, the critical aspects is that the central government should come up with certain schemes for the benefit. So we also realize the lack of law itself specifying these critical aspects. On the same note, the Parliamentary Standing Committee report on the Industrial Relations Code 2019 also recommended, and I quote, with the view to enable workers to avail the benefits of various labor laws, the committee desires that the scheme workers and the gig workers and all workers engaged in the unorganized informal sector should be included and should have a unified definition of employee bar worker. So this being the context in which we are discussing. So even though when we think that the labor laws, we realize that there are certain key changes that have happened, but still somewhere we lack the required amount of the protection that should be offered. Let us move further to see probably what are the challenges. Hemant, we have sufficient time, right? Yeah. Okay. Fine. Yes. Yeah. So this was the background, and I was just trying to give you all the bits and pieces to put it together in terms of understanding. So now let us see probably that what are the challenges generally faced, or what are the challenges that the gig economy worker, and how does this come into picture when it comes to an employer-employee relationship? How these functions, why is it important? That's the critical question. So we can see that this is just a graphical representation, which just to tell you that probably these are certain areas on a traditional settings where it is the benefit of the employee, employment and income security, safe and healthy workplace, enhancing productivity through on-job trainings or such other career advancement programs, a stable economy as far as the way in which the life is motivated, motivated, a voice that can be heard. When we talk about people's participation in different corners, and I'm sure that would have followed how probably the voice of people becomes important, and even voice of a child becomes important in the UN Convention on Rights of the Child. So where the voice of the employee becomes important, fair treatment in terms of, even if it is to the fire the person, or when the contract is ending, or whatever reasons for which probably you do not have a healthy relation, a fair treatment between the employer and the employee, equality of access in terms of non-discriminatory work atmosphere, so on and so forth, and in toto a social protection that needs to be done. So these are certain factors probably have a huge influence in the idea of how the employment, how the relationship needs to be done. But as this being the challenges, let us also look at each of these aspects, figure out how probably that are reflected. So in this line, when we look at the challenges that are and what made us think through all of these, is the main reason is the spread of pandemic. It also brought before the gig economy. I'm sure that we heard the voice of migrant laborers, but somewhere we lost out in terms of the gig economy workers as well. So the either options, two options that were left for a gig economy worker probably was to have, or operate at the forefront and serve the essential facilities or essential needs of the lockdown population, or probably, but this also has the health risk that is associated, or if that isn't working out, not the essential, even the essential needs are if that is not possible, there could be other option, is that you travel back to your native place or live on your earnings or just the savings that you had, and also may not be certain situations could be where you are left with no income at all. And please remember, when we are discussing this is also the context in which where the freelancer may not have received the payment as well, and COVID has become a quick reason to say that I do not have money that needs to be paid, that for the work that you have done. Of course you have done the work, but I am not in a position to pay you in that context. So, and definitely we have seen that the round of pay cuts, how that had been initiated. So be that as it may, see all of these, the question here is the health risk that probably essential need delivery person would be holding, or in those lines. And it is also on this lines of how probably social security, the whole lot or whole idea of social security being hampered in that matter. And of course, yes, we had seen certain relief packages announced by the finance minister, which addressed, to a certain extent, addressed the concerns of the organized sector and the workers, construction workers for that matter. But sadly, there were no mention, or it was not directed towards the gig workers as well. And I'm sure that you would also ask that, okay, since we do not have how could we do this? So in this context, the social security code that we discussed earlier was, of course, the first step to identify the need and requirement to provide social security in an unconventional gig workforce. But there are certain questions to it. So I'm sure that you will ask that when you said that, okay, there have been certain relief packages that have been offered, but for gig economy workers, there is no package or there is no such benefits. But the question arises that, do we have clarity in defining who a gig worker is? Again, let's go back and realize that, see, in the present day context, there have been nuanced definitions of the gig workers themselves. Like, for example, if you look at ILO's definition, or how ILO tries to come out with how non-standard practices, non-standards work arrangements, what are the different non-traditional work arrangements? See, for example, crowd work or work on demand apps. The state of California, this was something that I had already mentioned. So the problem of defining. So this is what I was saying, that how probably that we had certain tests that was done. So as far as state of California is concerned, they had three critical questions of how probably you can link a employee and an employer. So what is the relation between them, and to what extent these beneficiaries of work related rights and protection. On the similar note, the European Parliament also passed a directive on transport and predictable working conditions in EU, under which the beneficiaries of social security are identified by the duration and nature of work in a week. So unlike the concrete EBC test or EU directive, the code do not lay down any clear test or standard or threshold that needs to be identified for a gig worker. And the absence may be problematic when it comes to implementation. So the challenges include from, or it starts from the very definition of gig worker. And the next includes how probably employment insecurities creep in, which also could result in the issues of how social security coverage and on like on that context, it is also significant to note how mental health and well-being, it is often a discarded offered as a person who has worked in this field, or like the kind of the remuneration that you receive, that is probably like it could also bring in mental peace. And I'm sure that nowadays in the social media platforms, you would have seen that how probably how salary was a person, if the from how probably the payment itself, the notion of how probably you become completely broke towards the end of the month, or you're working on a project, money isn't received, you totally become a different person because you really do not know how to connect. So it could also, and we have also faced that situations where we try to balance between our need, greed, and the money that we have when in the difficult times. So the mental health and well-being, and another important aspect probably when we look at gig work, the worker themselves, and also the company themselves. Like for example, the work culture that we talk about. So certain companies are clear as to what is the work culture that they would want to promote. They not only see the people as just their employees, but also as human beings, and how probably that needs to be helped in. And I'm sure that we have certain company names popping up right now where we understand the work culture and such other matters are important. Not only your work, the work that you do, but the culture that you show, the way in which that you discuss, and how probably all of these matters are important in that context. What could be so these being the challenges that we realize, probably what are certain of the important measures that we could probably look at that as a regulatory proposition, or what are the critical aspects that probably we could help in those lines. So what I would this is on this understanding that probably these are certain regulatory prepositions for the future of work. And I'm sure that we realize by this time we have already seen how the growth, or how probably the rise of gig economy workers and their need to be protected, or their the rights, the privileges that they are associated with needs to be protected. To start with, we would require an equitable, inclusive, sustainable social protection that is offered. And this comes from none other than our sustainable development goals. So when it comes to sustainability or sustainable development goals, the key important aspect is that this also falls under the idea of how human rights and international labor, or the principles of international labor also are in the intersecting points. Like, for example, if you look at how the social security standards can bring in the policy maker in strengthening the social protections, universality of protection, coverage, and effective access to it. So probably it could also be on this lines where, in the UK during the pandemic, they had provided for a social security measure. They tried to provide for a database and social protection measures in terms of health insurance or certain minimum wages that are provided. That could be sustainable wages, the wages that could be done. So there are different methods in which we could do all these systems of social protection. And in those contexts, and so another approach probably we could look at is the human-centered approach for the future of work. This is yet another rising concept of understanding how labor and the approach of work needs to be humanized in general, how human rights principles are significant, not only the principles of non-discrimination, but also the opportunity to growth and well-being. Mental health is also part of understanding. In terms of adequate social protection, social protections need to be provided. Please remember, when we talk about social protection, it is not only that we have to prevent poverty, but also to bring in a decent standard of living. It also falls under the concept of how living wages are, or how we understand living wages in that context. And another important aspect is the transparency, which ensures that actors are fully aware about their legal responsibilities. It could be the corporates that they are involved, the project heads that they are involved. So it could be the labor or the workforce or the employer or the state itself has certain clarity and is transparent enough. Last but not the least, but the most important point is to have ethical responsibilities of businesses and the business and human rights framework, which talks about the three pillars of how respect, protect, and remedy framework. These could also be used to identify the future of work in that context. So this is just to give you a broad idea. So future of work needs to be looked at how we perceive employment or career on a long-term basis. And this also is significantly affected by all of these matters. So in this context, I think these are probably few prepositions that we could work on to realize that how gig economy workers could be provided with adequate protection. So in this is a brief roundup about how and what are the critical issues that we are looking at. And these are the few references that help me to gather all of these thoughts. So there have been few questions that have been raised. I'll address the questions. So this is the reference that, or these are certain of the materials that help me to gather and understand what is the topic in that level. Give me a second. Yeah, so there have been a few questions in that manner. So I'll just start in order to understand. So Rupali has asked how labor laws in India protect gig workers, what are their rights, so on and so forth. So whatever that I had discussed, so where there is a lack of clarity in those lines, so I have broadly provided for those. So that can also be looked into in that context. And there have been also questions of how probably what are the recent changes that has come into picture. And they have also questions about how is it probably that organizational models which also look at, or which promote the workforce is also looked into. And I think the first question is the question is how could you please throw some light on the collective bargaining aspect. So that's yet another interesting question that I could say as to how the question being how collective bargaining, that's an interesting preposition. Why I would say is that, see, that is that area of understanding of how collective bargaining could be used as a tool. I haven't covered it in the presentation for the simple reason that it might be like, that forms another set of masterclass requirement. But nonetheless, probably what you can look at is to bring in more inclusive and labor markets. You can look at how the ILO working series, the report that they had produced on organizing on-demand representative voice and collective bargaining in the gig economy. This is the ILO series, the working paper series that ILO had produced, and this also gives a detailed list of how probably that will help you to understand, or how this technically looks at the different aspects of collective bargaining, how that can be used. Of course, sadly, this is not something that we have generally we have not used it in those terms. And the questions about how, the next question being how probably what are the other jurisdictions, or how gig economy workers are protected in other jurisdiction. Do we have any exact example or model that we can replicate? Of course, adaptability is required, or adapting to our needs and requirements are required. But I would definitely say that the world is largely talking about inclusive work points, or the inclusivity nature. That is also something that we have looked at. So it may not be right on my part to say that, oh, exactly we have, but of course the measures how I mentioned about how the UK provides for the social security measures during the pandemic, that is a critical example of showing how inclusivity is brought in. And also in these lines, I'm sure that yet another area that we have not critically discussed is about how there is a how there is a difference between or what are the current trends, or what is the change that we talk about, what is what has the key aspects of the changes, recent labor law changes. I'll quickly run you through, because that is not the exact focus of my presentation, but nonetheless I'll just skim you through the different aspects of it. So basically, when you look at the 2020, we tried to codify and consolidate various labor codes. I'm sure that would have kept track of it, of how code on wages, code on industrial relations, code on social security, code on occupational safety. So it also tries to gather somewhere around 40 odd legislations, trying to come up with one solid one. So each of these codes have separate measures that we have looked at. I'll just skim you through, because of the paucity of time, we may not be able to take up each of these. So definition of wages, how probably the single uniform definition is applicable in terms of minimum wages, payment of wages, bonus, etc. Separate definitions for worker and employee. Minimum Wages Act has also undergone certain changes. And in terms of Code of Industrial Relations, over 100 state and 40 central legislations have been regulated in that manner to improve the ease of compliance. So it is also on a business friendly nature that we look at, but not only the benefits for the workers are also provided. In terms of Industrial Employment Act, the standing order, so there have been certain changes in these acts as well. And in terms of social security, the code tries to simplify and amalgamate and replace certain central laws of the one that I discussed earlier, that is the Employees Compensation Act 1923, Unorganized Worker Social Security Act. It could also be because of Payment of Gratuity Act, Cine Workers Welfare Fund Act, so on and so forth. So there is a list which they tried, and there are also important definitions that we have looked at. So there have been key changes in terms of sickness, maternity, and other benefits that are provided. And these are certain things that probably a simple search would also tell you about how, these changes. And the code on occupational safety, so and that has also undergone certain changes to include health or regulate the health and safety of the workers. So, in short, when you look at these are the simple changes or certain changes, but of course, criticisms are something that we may have endless criticism, which may not be possible for us to look at. So there has been a question that is there any law that is going to be implemented? So that is what I said in the central, this code on the code on social security talks about the definition, but it asks the central government to provide or start with the schemes that are required, or come up with schemes that would help or protect the gig economy worker. So these are the certain issues that are related. Unfortunately, there are questions coming up, but we are not able to take up. But please remember, we from Daksha, you can expect a blog series on labor, and also we are also trying to come up with a primer which talks about the changes, and we also would want to hear about how probably and also I'm sure that there is one question on how probably work from home, how that has been, how there is no regulation. So there is a piece that I had written quite earlier. It's up in the Live Law, our media partner. So probably one that you can have a look at, and then you'll find out how probably work from home is excluded from this category. Home-based worker is also not excluded. And I realize that I sometimes becomes passionate to say this, and then I really don't end the talk in that manner. And I can see Hemant trying to tell me that yes, Professor, it's high time that you stop. So as I have sufficiently provided you with the details, I hope to see you soon with other topics.